May I please? First, I have to mention for listing, my lord. Matter regarding to no confidence motion, my lord. Service is already completed, my lord. Need
When
it.
do you want?
Hmm?
When do you want?
129.
When is
Yes.
tomorrow? Oh,
No, no.
next week.
Next week, my lord. Most of it.
May I please? I beg to mention for listing a matter tomorrow or day after.
Motion matter.
Motion matter.
Motion.
May I please, Your Lordship? I beg to mention for listing a matter for withdrawal, Lordship. Tomorrow. Oblige. May I please, Your Lordship? I beg to mention for listing for admission matter.
Matter of which year?
Matter of 23.
What is
Matter
the matter?
relating
Subject matter.
to they are the beneficiary of Atal PMCY scheme, my lord.
What is the urgency?
But their house was not given, my lord.
Mention is only for out of turn.
A recommendation for listing of writ petition on Friday
What motion matter?
and
Which year? Matter of which year?
which week?
What is the subject matter?
For
No confidence. What is the term? When is the tenure coming to an end?
December.
I beg to mention, I beg to mention for listing or IA order
IA for?
because for vacating the stay order because of the
When did
stay
you
order.
file?
Yes sir.
21. Friday?
Friday, Thursday,
Not Friday.
Lord. Because urgency is there, Lordship, they have got that
Get it numbered, registered.
Friday.
May I please, Lordship, I beg to mention item number 10.
Yes.
Kindly adjourn the matter for the day.
Inform the other. Have you informed the other side? Yes, sir.
Wait.
Government. Who's that? Union of India also. Your first Union of India. Madam? Item 10. 21
Next week.
on the prayer made on behalf of the your man making a mention on behalf
Mr. Peter Saika.
of this after.
Password.
Sorry?
My tenure is on paper.
Who's this?
Number one. Yes, sir.
My lord, what he did yesterday, they refused to accept copy. My lord, my lord, kindly see. I don't think there is a separate constitution for Karbi Anglong, my lord. My
Yes.
Patta land,
Nowadays, so why do you refuse to accept copy?
No, we
his senior initially refused, my lord. Well, I'm shocked. My lord, nowadays some of the advocates have started identifying themselves with the illegal activities of the respondent. I'm very sorry to say that. Well, kindly see, my Patta land, they are making construction, they have started demolition without notice anything. And he is the man who was the first CM of the my lord Karbi Anglong. They donated the land, my lord. The stadium and all these things were come up on the land donated by the grandfather of the present petitioner. Well, they want to construct a flyover, they want to widen the road. We are not opposing that. Follow the due process of law. Article 300A gives me that constitutional right. Well, they have started, yesterday night they have started demolition, my after they received the copy. Initially, they did not accept the copy on the ground that X has not been made a party. Who are you to determine? This honorable court will say if the
Who has not been made a party?
Mr. Jointa Sutia, my lord.
No. Who has not been made a party?
No, they say initially the reason for not accepting copy was so and so has not been made a party. My lord, with all sense of sincerity, I'm making, my lord. I think time has come, my lord. Some of the officers should be pulled up, my lord. Are they not aware that Patal and over Patal and they cannot do all these things? Is there any requirement? My lord, because up to 2 o'clock they can do further damage. That's why my learned friend is not before your lordship. Why the other this is court is not important? Other court is important?
No, we'll have it after some time. No, we'll not wait it.
After 10-15 minutes, fine.
Okay.
Yes.
Please, your lord. Yes. First, even this matter, Mr. D.K. Das was speaking, but he has got a family function this week. But may I pray, my lord, Tuesday next, coming Tuesday.
So the recent matter.
My lord, correctly. Actually, I was out of station. And yesterday he told me
Because
that he would.
Karthi demands that I should have been informed. He said 2014 matter.
Why didn't you inform
It's
yesterday
a
last
very
night?
simple point. They have asked for a mandamus against a private individual.
Mr. Vitala, granting an adjournment is not big, but
Correct, Milind.
At least
you should have informed. Why should he waste his
Miller-
time in the evening?
I was not informed that my senior would be appearing. I was informed that
Correct.
Mr. A.K. Phukan was,
Mr.
Whoever-
Gonzo was appearing after his
However,
he was earlier at
the
that point of
courtesy of the courtesy at the bar should
he
be
is already
maintained,
in grief from day before yesterday. Mr. Pathak,
my lord.
you're already in grief from day before yesterday.
I am
You're not in grief from day before yesterday evening.
my lord.
Entire India is crying.
My lord. I am already in grief. So that griefs become more when they ask for time now.
When can I have?
Tuesday, next, coming Tuesday. Milind.
That district does yes, very I actually just have applied that complete money in that, then India would have.
Correct.
This court will not like to make any comment on it.
Kundari.
Maybe Mohanta would also not have made the comment if he was in
Right.
service.
29th.
Lordship, Kundari like
8 of
Huh?
28.
Put in my paper.
Good for
Fix the date.
others.
What is the issue involved?
My lord.
What is the issue?
Issue is, my lord, they have asked for a writ of mandamus against me. I'm a private individual, saying that 650 square feet of godown area day one at a rental of 2,000 rupees. And second prayer is that writ appellate court, which passed the order in 2000, because in order to save limitation, now that it is barred, saying that the advocate did not inform that writ appellate order and contempt order. Therefore, I am in a writ again.
Court
I am, my lord, I am the owner of a landed property in Phanchi Bazaar. My lord, what happened? In 3 sentences, can I give?
Mr. Bitala, how can you enforce your right
Page
as a
number
private individual?
Page number 10.
Milind, this issue was raised on the
And these are essentially matters of civil nature.
Yes, page number 10, your lordship.
How
will
do you
look at everything.
fix the monthly rent?
Milind,
All
there
these
was
can
an
these be
order of,
matters of jurisdiction?
in fact, Milind, that was a matter before this honorable court, wherein a direction was issued by this honorable court stating that I am entitled for 550 square feet in the basement. The area was not mentioned. It was stated that I am entitled for an area of 550 square.
By a writ appellate court.
My lord, this appellate.
Writ,
But the
writ,
High
writ
Court.
court.
High Court.
Thereafter,
Thereafter, my lord, we did not file the contempt petition. My lord, he violated, he did not provide us this property. We
okay,
did not fi-
we have to say the Bitala.
my lord, that-
Appear for a judgment on behalf of DK Das. P. AP Patrick. Appealing for private restaurant number 2. However, why is that and he also raises
Issue
the
of
question of maintaining considering the above one and taking into consideration the ground site for the judgment, a short accommodation is done. Direct
28.
28,
My
28,
Must have-
Tuesday.
lord.
Next time there is no adjournment. So no requirement. is
I
coming.
would not have said so, because young at there, our future, at least something to
In
be.
this case, no adjournment. Other
May it please your lordship. So I heard your lordship, the private respondent has been informed that they will be engaging new set of lawyers. That's just for the information I am stating, your lordship. I am for the petition.
there is a private
Yes, yes.
4 and 5.
4 and 5. I'm for the petition.
What is this matter?
Yes. Lordship, by this application, we have challenged the order of the
Is there any
Board
order
of
that,
Revenue, yes, Your Lordship. The impugn order is at page 52, Your Lordship. This is the order passed by the Board of Revenue, Your Lordship.
you are against the
Against
the
that
Board
order.
of Revenue?
Yes, Your
52.
52.
Yes.
The relevant portion is at page 53. The penultimate paragraph, Your the last paragraph, in fact. If I may read you.
Please.
It is seen that the Lawrence Settlement Officer has not.
You are the appellate in the APR.
No, yes, I'm that. I was that. It is seen that the Lawrence Settlement Officer has only restored the names of the pataders that were there in the old dug, out of which the new dug was created. As this person had not transferred their rights to one single patadar, the new dug curved out could not have been in his name. This is purely civil in nature, Your Lordship. First, and finally, the last sentence, Your Lordship. If they are dead, their legal heir would take their place. Possession has to be accepted even if one patadar was holding the land. Possession by the appellants amounts to possession by 13 original patadars. So it is admitted that I had possession over the plot of land. And it is said that since I had possession, the others will be assumed that they have possessions with me because they are distant cousin of mine. That cannot be a.
What's your cause of it?
Yes, Your Lord. The fact of the case is that if Your Lordship may kindly come to page 21.
Mr. Sharma, is there any office note regarding the appearance?
No,
private
no,
respondent?
this is just the information I received today, Your Lordship, that they might be engaging a new lawyer. But I am not sure.
Who the earlier set of counsel has informed?
Who? Huh? Yes, yes. They have given up the brief. That is the information we received today morning.
Will have this matter, but may not be.
Lord.
Let us give a
Yes, yes, definitely. That's why I informed
we
you.
have been fighting
Yes, sir.
from this. But we'll fix it.
Yes, sir.
Today is Tuesday.
Tuesday.
We'll have it on next Tuesday,
Next Tuesday,
28th.
28, Your Lordship.
Day after tomorrow, maybe third.
Yes, yes, 28.
Learned count has formed has some as per information by if I are as per information received by him, the earlier set of counsel private have the brief and take response are like engaged after that. Sarah, today none has appeared for the number
4 and 5.
consider nature of the issue as well as in consideration that it is a year a short adjournment to spend the contest to a put up this column up on it 11 2000 completed by no further
I am for 2, 3, and 6.
Oblige.
May I please your lord. Your respondent have filed their affidavit in opposition, my lord. The record file reply, my
when was the affidavit filed?
lord. We have received a copy on 17/7/2023.
Here is 11 can accommodate you for today, but they have chosen not to file for the last 3-4 months.
My lord, next week, my any
Not so good. Not file with unacceptable matter. What's your name?
A Gayan. I'm on behalf of the TK Munir.
What is
For the petitioner.
For the all the respondents.
A Gayan.
how to take a- very good- get- get- what is that? That addition is what
My lord, it is an additional affidavit filed. It is original affidavit filed earlier.
get filed on 7. Not also 30th of 30. 1 week.
Much obliged, my lord.
Not a front. 15 minutes. 5. However, that's no but
On 30th.
Thursday night.
Ma'am, the petitioner is not interested to pursue with the matter, but it may be withdrawn, my lord.
CWD rules, anybody? You talk about now. Yes. Government advocate, anybody? As MSS, as not.
Obliged.
Sutia?
There is court number
It's
30.
going on now, my lord. Demolition is going on. Just now. We got this.
10.
Another 5 minutes. We'll take it.
For 10 minutes.
In court number 20. Kindly pass.
We just did trial.
Lordship, kindly see the several orders, my lord. When the matter listed, my lord, in any court, my lord, he remains absent.
Lordship,
Or like- We'll have it after some time.
Yes, yes, my lord.
The borough of
No, I'm for next time.
yes, the borough of
Yes, my lord. This matter relates to payment of pension to unmarried debtor and unemployed debtor of freedom fighter. Now, in practice, this, my lord, other of the petitioner was getting pension both central and state, my lord.
I think we have decided one of the matters.
No. Once it is come before lordship. Now, here, my lord, now, you appear going on. Central government. Here, my lord, question has come up. After date of that father, mother was getting up to 12, December 12. Thereafter, this was the application was filed by her daughter, this present petitioner, before the deputy commissioner, that after date of my mother, I am entitled for this as per notification and the entitled. There is no doubt in that. Thereafter, what happened on the basis of that order of deputy commissioner, now I am getting pension state pool, but I am not getting central pool. That is why I am before your lordship today. Now affidavit has been filed by central government supporting one notification dated of 2014 that after date of my murder, I would have approached to the concerned bank or treasury office immediately within 6 months. And if not thereafter also it can be, but that is from date of application I will be entitled. I am not denying on that point. Here question will come, my lord. Before that 2014, my case was in 2012, my lord. That time 95 notification is governing. I will come on that. As per notification, there is no time bar, and that was in time it was been, I'm getting state pension, but there is no denial on that point because state central pension only not given. That notification may not come, my lord. It's your lordship will decide on that point. Thereby what happened, if come also, if required, will file application, if required, your lordship direction. But if 2014 notification is governed, then they will, according to that notification, that I will be getting some date of filing of application, not the arrear. Now, question is that whether I have already applied in 2012 itself. 2013 I have been, and the deputy commissioner has clearly passed an
You're
order.
only concerned with the area of this.
No, not even. I'm not getting anything now. Central pool, I'm not getting.
Let's talk about
Yes, one RDB is required. Let her come because she is defending. Maybe
no,
take
are you there? You are
Is it?
not disputing claim. Are you?
No, if it is,
No, is the claim disputed? Is your claim disputed?
yes, they are telling because I have not filed the application within 6 months.
No, not on the procedural aspect. Otherwise, is your claim as a dependent daughter?
I'm authorized.
No, is the claim made by you disputed by the respondent, or is it only on procedural ground?
No, that is not. They are not disputing. They are telling that you are entitled, but as you have not filed application,
That is what exactly you are
that
trying
is
to ask.
that is why.
On
Now my-
merits, they are not disputing.
not disputing.
They
I'm
are saying
entitled.
that you did not apply in time.
That is what. But I have applied. And that to my lord, they are taking support of 2014 notification. But my case was in 2012 case. That time another notification is 95 notification is governing until. Let her come, my lord. My lord, that will be better. So after some time, I'll call him.
If you are not disputing on merit,
No.
then her entertainment is not for the filing of an application. Her entertainment is because the daughter of a freedom fighter. The filing is only a procedural aspect.
That is,
You are saying that dependent or independent daughter not that's a different aspect. They have to go into
no, they are not telling.
Here I
Entitlement is there.
entitlement is not disputed only
Huh?
because of the fact that an application has been filed at a
Yes.
belated stage.
Yes.
That
According to
is
them.
entitled her for
According to them, my lord.
this let us
After some time, my lord, I'll call her.
yes, come. Madam,
Lordship, as per guideline, Lordship, she has to apply within 6 months.
that is exactly we are trying to discuss. You are not decided, you are not dispute claim per se.
Yes, Lord.
You are saying that the application was not filed within that time.
Yes.
That is what
And
her
now she has to apply to the ministry, Lord. Ministry will consider whether she is eligible for the pension or not.
she has already applied.
No, Lord. To the ministry.
Lord, you welcome.
Have you applied or not?
Yes, we have applied before the deputy commissioner in 2013 itself.
No, in the
There-
before
there-
the
that-
ministry.
There is a not procedure. 2014 was not the procedure.
You
that
do
time.
one thing, Mr. Burwa.
My lord.
You do one. We could make it a viability. You file an application. We'll keep this pending for the ministry. Let them consider. Because we do not want your claim to be decided and in after a final order is passed. Let it be decided if it can be released well and good.
Yes, yes.
Otherwise, let it be.
Then that matter may be pending
You will
during
give it-
pending here. I'll file application. Then let me, because I'll pay
that I think he's out.
all, my lord, in that way, I'll file also that representation. I'll mention also that 2014 is not governing. That also will come.
Whatever you heard, Mr. Burwa, when it comes for
Petitioner.
raised by the dependent
Unmarried and
the
unemployed
dependent,
daughter.
who is an unemployed and unmarried daughter of a freedom fighter is towards the payment of SSS pension with Pakistan. Case of the that such pension from is being
Agent.
and however after death of her mother the pension from central government on state has not released.
Yes, that is.
Sarah. It appears that after hearing the Barua as well as heard the comment, it appears that the non-payment of central pension is more on the account of not making an application for the ministry, and the entitlement of the petition as such has not back from this while the petition is at first is given referred to file necessary for the ministry and on filing such a is considered and disposed of by which is be done in a period 60 days from the date of receipt of yep. This on 17 end of January.
Yes, but yes.
In the 4th of January.
Well, obliged.
My lord, demolitions are going on. Lordship will kindly take up the matter. Yeah. My lord, prior to this, my lord, there was another round of litigation. This was the order passed matter. Yes, my lord. Kindly come to page 3 of that order, my lord. Grievance raised in this petition by the petitioner is that they have been issued eviction notices that is so and so. It is submitted the land on which the petitioners are presently occupying is partial land of the petitioners, and therefore petitioners cannot be evicted without following the due process of law. Accordingly, by filing the writ petition under Article 226, petitioners have prayed for quashing of the impugn eviction notices. That is so and so. So it was the case, my lord. Now kindly come to my lord, page 4, para 7. The learned standing counsel for Karbi Anglong Autonomous Council has submitted that he has no instruction that no construction activities are going on over partial land of the petition. Accordingly, this court is of the considered opinion that petitioners have approached this court being aggrieved by notice that is so and so. As respondent number 3, joint secretary to the council, department has withdrawn the said notices. This writ petition has become infractor. As the learned standing counsel for the Karbi Anglong Autonomous Council has categorically stated that authorities are not encroaching on the land of the petitioners to carry out construction, the court is inclined to close the writ petition with liberty to the petitioners to approach court again if so advised. If any part of their partial land is encroached in course of construction activities being carried out by Karbi Anglong Autonomous Council for construction of 4 lanes so and so to the depot post office. So, my lord, clearly, but their case was that the construction is not being. My lord, we say these notices are bad in law because it's a partial land, it's not a government land. Rule 18 can be invoked only when, my lord, the land is government land. So since it is a partial land, they could not have. Then they withdrew the notices, my lord. Then, my lord, this honorable court gave us liberty that please you can approach again. So we are before your lordship. Now we are agreed by this order at page number, my lord, 27. Yes, this is the notices, my lord, which has been issued to all of us. Now, earlier they said, my lord, they will not make any construction on the Patta land. That was the stand, that's why the repetition was closed. Whereas the authority of the autonomous, Karbi Anglong Autonomous Council, DPU, has taken up development project along the road from Rongninghang to Difu head post office, measuring a length of 1.5 kilometers. Whereas development work involves widening of the road and construction of flyover.
It is under 18,
No, they don't mention mine.
it is
Yes, it's 18 feet. Yes.
but it is Patal.
Yes, it's Patta land.
How is it coming into?
It cannot come, my lord. Once they had withdrawn such notice.
Where is the document?
Yes, my lord. If a lordship will kindly come to page 13.
One.
1-3.
It's hard.
Longkiri Terong, that is petitioner number 1. Periodic Khiraj lease patta showing that the petitioner is the patta holder of the plot of land bearing Dag number so and so on area of 2 bigha, revenue receipt, etc. Similarly, Sujit Terong, my lord, he is owner of 3 katha.
Patta detail.
Yes, all the details are here. So this is the schedule.
That is your case.
Yes.
Yes.
My case is very simple, my lord. If you want land for widening of
no.
the road, you can take.
Yes.
No, my lord, there's one more thing, my lord. This is a national highway. This is national highway number 29, on which the construction is being made. Therefore, if they want, they have to invoke this act,
And it's
national highway, which they have not done. And my lord, where is the question of if you want to take over immediate possession under section 80 of the 2040 of the 2000, pay us 80% compensation first.
no, that would be an acquisition process,
Yes,
if at all.
yes, at all.
If your Patal and it
No, doesn't apply. So therefore, I am praying for stay of these notices and for it staying the my lord demolition process.
My lord, look into 18.3, my lord.
no, are these Patal land?
My lord, petitioner has stated it is a Patta land, my lord, but petitioner has not annexed the Patta.
No, are you disputing?
My lord,
Yeah,
at
the
least-
evidence we can get later
my
on.
lord, my lord, I am submitting it, my lord.
The
If it is-
notices were,
My lord,
no, Mr. Tutia,
My lord, if it-
notices were issued on 8/11.
my lord, 15 days it is up to 23, my lord, asking to vacate. What is the, my lord, Patta, my lord? There is a condition, Patta is issued under certain terms and conditions, my lord. That is one of the conditions of the, my lord, Patta.
No, Mr. Tutia will not, if
My
you,
lord,
if you are,
just
if,
look
no,
into
no,
it.
if you can wait, definitely consider. But if you are arguing that aspect, we hear that
No,
matter.
my lord,
But if you are agreeing that Patal land,
if the Patta
in
land is,
principle
my
also,
lord, if the Patta land is also there is a condition of the Patta that up to 35 feet the government can take the land, my lord, without paying compensation. That is a condition of the Patta, my lord. If the condition of the Patta is there, my lord, Peter has not annexed. First, we look in the copy of the Patta, my lord.
Well, I'm having all the pattas, my lord.
My lord, there is a condition, my lord. There is a condition number 4, my condition number 5, my lord.
please read.
It is in the, my lord, in vernacular, my lord. If you lordship, Ali মেরামত কৰিবৰ নিমিত্তে
সেই মাটিত বা তাৰ
গভৰ্ণমেণ্ট বা গভৰ্ণমেণ্টৰ কাৰ্যকৰসকলে
read from first line, the 5 years,
5, my lord,
সেই মাটি
আলি মেৰামতি কৰিবৰ নিমিত্তে, my lord, my lord,
5 started, সেই মাটিত বা তাৰ তলত
my lordship will look in.
তলত থকা শিলৰ খনি আন
No, that is
কোনো
not, my lord. That, my
Yeah.
lordship will,
this you have
condition number 5, my lord.
আলিৰ মেৰামত কৰিবৰ
4, আলি মেৰামত
District
কৰিবৰ নিমিত্তে
Council-
ডিষ্ট্ৰিক্ট কাউন্সিলৰ কাৰ্যকাৰকসকলে কোনো লোকচান নিদিয়াকৈ সকলো প্ৰাদেশীয় বা লোকেল বোৰ্ড আলিৰ কাষৰ বা ওখ আলিৰ নামনিৰ পৰা 35 ফুটৰ ভিতৰত খেতি সম্পৰ্কীয় মাটিৰ পৰা কাটি আনিব পাৰিব আৰু সেই মাটিৰ বা তাৰ কোনো অংশ থকা তাত শস্য লাগনিগ্ৰস্ত বা ঘৰৰ মূল্যত বাজে আন কোনো লোকচানি নিদিয়াকৈ ল'ব পাৰি। গতিকে that is the condition of the patta also is there that up to 35 feet the government has the power to take the land for development project or for construction of the extension of the road, my lord. If that condition is there, my lord, the council has the right, my lord, to get that land, my lord, for construction. And for that purpose, that they are not getting the land compensation, they are getting the, my lord, only for the Jirat fund. And that condition is that if the petitioner have that quota, my lord, let them say that there is no condition of that fund.
Is what you
And if
My lord, merely because a condition is there, my right will go away, my lord.
how do you
No, my
react
lord,
to this?
yes, my lord, I'll make my submission. This condition means, in case, my lord, this is required for any developmental activity, the government can take the land. But my lord, to take away my right to
One
receive,
common product.
yes. I'm reading it again, my lord. সেই মাটি বা নহয়, sorry.
Ali,
আলি মেৰামত কৰিবৰ নিমিত্তে ডিষ্ট্ৰিক্ট কাউন্সিলৰ কাৰ্যকাৰকসকলে কোনো লোকচান নিদিয়াকৈ সকলো
now,
প্ৰদেশীয় বা
now, Mr. Chaudhary, we could have, if this is the clause he's trying to rely upon,
yes,
you have to go by the literal meaning of this clause.
yes,
It is for meramot.
মেৰামত,
It's only for,
মেৰামত,
it's for meramot.
মেৰামত.
Repairing.
Number one, মেৰামত,
You are
and
constructing.
secondly, my lord, খেতি সম্পৰ্কীয় মাটিৰ পৰা কটাই আনিব পাৰিব। খেতি সম্পৰ্কীয় মাটি। My lord, this is unheard of, my lord. When there is a
Mr. Sutia,
constitutional,
let us think it very broadly. If you want this land,
my lord,
you have all the powers under the Act.
yes,
my lord,
You have the Act of 64, local Act, you have
my-
the
my-
Central Act,
my-
acquire the land.
exactly.
Why are you taking it by means of by foot? And then patta land?
not by force, my lord. If it
So
is,
if you are going by 5, it's meramot. Is it meramot?
my lord, it
Or is it a meramot work?
my lord, if the road is, my lord, extended, my lord, to a, my lord, more than,
Extended
my
is
lord,
meramot.
my lord, it
What
can
is
be
the meaning of
done
meramot?
like
Let
that,
us
my lord.
understand what is the meaning of meramot. If you are going by this section, let us also go by this section.
And my lord,
Literally,
my lord,
meramot is repair.
If the existing
and then
road
we
is
will-
there, for the, my lord, if it is
No,
that, for,
this is for construction of a national highway,
national highway, my lord.
29. Not a small way or something you want to broaden it or something like that.
My lord,
The
today, my
major
lord,
work, you acquire the land, you have been doing it in Karbi Anglong.
my lord, in the highway, my lord, when the highway construction is going on, my
There is
lord,
a special act, the NH Act.
NSTech, my lord, we are doing it, my lord, in that, my lord, when the construction of road is going on, my lord, but it is
Quite
in,
your response. Don't go ahead. Third. Speak. Again, so next. Petition. The petitioners have to challenge notice dated 8/11/2020 or 8/11, all 8/11
my lord.
issued to them,
And 15 days, time is also
Whereby-
not over. It will be over tomorrow.
whereby to the petitioner
Or-
purported the answer.
whether lordship will fix it on Friday, my lord, I will take the definite instruction whether it is from the government land or from a portal
We
land.
can have
Right.
purported the answer section 18(3) of the Assam Land and Revenue Regulation and 83 of the rules framed under the Assam Land and Revenue Regulation, 1880. By the same notice, completed has given to the petition to vacate the land as the state is required for development of the widening of a road and construction of highway. Within a concept of the petitioner has submitted that the land question are pattaland, the details of which is given in a chart in paragraph 30 of the petition, and therefore contends that there will be no application of Rule 18(3) of rules in question. He further submits that the area that the road in question pertains to NH 29, and there are different statutes, including the National Highway Authority Act, NHAI Act,
National Highway Act 1956.
National Highway Act, under which detailed procedure for acquisition has been laid down, and the same act has also not been put into operation. A. Chutia, Learned Standing Counsel, he is, while opposing the writ petition, has submitted that even for a patta land, there is a clause in the patta that for the purpose of repairing of the road, the council can evict the patta holder up to an extent of 35 feet without any compensation, and only zero compensation will be paid. Full stop. Para. Three, Chutia, the understanding council further praise for further submit that he may be given some time to obtain detailed instructions and praise for fixing up this matter on Friday. Friday, Mr. Chowdhury? Friday.
Let it be.
Friday, are you there on
Yes,
Friday?
I'm there.
Para. This case for motion on Friday. Para. Sri Chowdhury, the Learned Standing Council prays for some interim protection.
Yes,
as he submits that as per information received even today, steps are being taken.
it's going on, my lord. Demolition is going
Are being taken.
Yes.
Steps are going on.
Yes,
process
demolition is going on.
Process is going on. Process of demolition is going on. Sir, considering the above and the fact and the aspect that the land in question is a patta land, wherein this court is of the prima facie view that the notices under section 13 under rule 18.3 would not be maintained, it is directed that status quo as on now shall be maintained till the next date fixed. Full stop. This para, let a copy of this order.
Status quo in respect of the land, periodic patta land of the.
Let a copy of this order.
Instead of that, my lord, the status quo, my lord, let there be a stay of the.
Status quo as on today, as on now, yes, as on now,
11 o'clock.
as on now.
11 o'clock.
Let a copy of this order be furnished the J. Chutia immediate for onward transmission to the authority for complying with the
And
direction.
my learned friend will communicate report with my lord. Yes. My lord, they will not go ahead with the demolition. Kindly
Let us go there. It is made clear, Farooq, that demolition exercise cannot be carried out till the next.
My lord, it's not para 13, page 13, my lord.
Then what's the paragraph? What's the paragraph?
The paragraph is, my lord, 8C, 8E, 8 small e.
8
E.
Para, let an extra copy of
It. Will give.
it for available.
And my learned friend will communicate just now.
Mr. Chutia, you kindly have one of your wrong, you collect from our court. The order copy will have it.
Yes, sir.
allegations against you, Mr.
No,
Kyle. You are avoiding this matter. But we had to defend you.
This is a normal allegation.
No, we are defending you. That he may be busy in some other court. This court is not important for him.
No, not that. But here in this case, the truck of the was seized.
Truck.
Yes, truck was seized. The lordship complication proceeding is going on. Lordship on the
When was the seizure made?
lordship is on 21.
Seizure was made when?
16/8/21.
20.
What was it contained?
Thereafter, her application.
What was there in the what?
Foreign made cigarette, and there was a allegation is that there was a cavity made in the truck.
Foreign made cigarettes?
Yes.
Okay, you have seized.
Yes, that is in seized and truck.
Now, why don't you release the truck?
No, lordship, that proceeding is going on. Lordship, I have.
Now, what do you get by seizing the truck, having it in your custody? Let him give whatever bonds is required.
No, lordship. So what happened?
Investigation is over. 21 matter.
No, lordship, notice under section 124 is been issued. Proceeding under section 115 is going. But we please to see the two letters.
No. What is the object in having the truck seized?
The lordship,
Do you need to further investigate or examine the truck?
No, lordship. The procedure is that the truck can be confiscated. Then order will be passed in view of confiscation. Some order has to be passed by the order. It is under the custom. Lordship on 3/11/2021, 23.
See, Mr. Kyle, here is a vehicle which was containing, which was carrying some goods,
Yes.
objectionable matter. Goods. Now, goods have been seized. He is saying that they released the truck because it's almost 2 years.
Yes, sir.
Now, the investigation has been done. The truck is lying with you for almost 2 years.
Yes.
What do you gain by having the truck in your compound?
But we will not get anything. But
Now, is it the truck is not the offense?
no, lordship.
Carrying the goods is an offense. You investigate the offense, you have the trial.
Lordship, here, lordship, custom act. If the truck is involved in carrying some contraband or illegal goods, then it is.
Are you apprehending that after having the truck, he'll vanish?
No, lordship. Here under section 115.
Let us
Lordship, please to tell you the two letters. Lordship, letter dated
which act are you?
3/11/2011.
No, which act are you?
Custom. Lordship, please to tell you also record.
Which section?
Lordship, section 110. Our application 108 in capital A. Our application for provisional release was rejected.
Which is the order?
Order at page 120.
Zero.
But no order, my lord, only communication.
Zero.
That's why, my lord, if honorable court was pleased to call for the record.
Thereafter, lordship, a notice under section 124 was issued to the petitioner and other persons who were found to be involved.
We're relying upon 110.
110 capital A.
That within the period of 60 days, my lord, they have to complete. 6 months.
Internet release of goods, documents, or
60 days, 6 months.
That was rejected.
Mandatory, my lord. Under 10A, be released.
that he had made an application under 113. That
Then it was rejected.
rejected.
If it is available in the court, if I
120 and 121.
but it may please
Yellow flag.
no, if the yellow flag is a letter dated 3/11/2023, where the petitioner appeared and she prayed that vehicle should be inspected. Because her allegation, her contention is that there was no cavity. She confirmed from the driver also. Then lordship on 10/11/2023, authority passed an order directed the commissioner Kalimganj where the truck is lying to inspect the truck and give a report. And I have an inspection that the entire proceeding will be completed within another 10 to 12.
My lord, let them follow the procedure. 110 says within the period of 6 months, they have to complete. And section 115, subsection 2, my lord, it
protects me, my lord, but they are not following, my lord. I have given all the documents. Lordship, kindly have a look. 110 2, my lord. 2. Both the goods and fees article section notice in respect of be given in the section 24 within 6 months of the seizure. Now, my lord, more than 2 years going on, my lord. To that effect, I have an judgment also, my lord. Now, Lordship, again turn to 115 subsection 2.
You say, within 10 days,
Entire proceeding will be disposed.
My lord, by saying so, my lord, they cannot overrule the act.
there is better
1011, it has been given to my lord. I know, my lord, they are going to see there is a plywood, my lord. Time and again, I have given them a document, my lord. My driver was used to run my vehicle at the rate of 50,000 per month. Custom authority asked me to give original. I have given them.
1011 letter says that there is a cavity.
No cavity, my lord, only double plywood.
That is what that is that this vehicle used to.
No, my lord, we cannot, my lord. I will give the bond, my lord. There is a judgment also I have annexed with the writ petition. Lordship, kindly have a look. Same stand was taken in Maharashtra, my lord. Maharashtra, my lord. Lordship, kindly have a look. I have annexed two judgments of at page 122.
I thought to work with provision.
Lordship, here in this
The 6
case,
months
Lordship, earlier she didn't appear. She approached this honorable court. Thereafter, Lordship, the authorities took the matter seriously and they are proceeding.
but
No,
how to overcome the how to overcome the limitation?
Lordship, which one?
Release to the owner.
No, Lordship, notice under section 124 has been issued and she replied also. Now the proceeding is to be completed. Lordship, because there are 5 persons.
No, 1.28 original.
It is a yes, provision.
Still reconsider your order, take it back.
That will be taken within 10 or 20, 12 days. Entire proceeding will be disposed of.
Tell give us a definite date.
Lordship may fix on 7th of December. 7th of on 8th, Lordship.
We'll have it on 4th of
Lordship,
for disposal.
And before that, Lordship, order I am giving. Yes, that proceeding will be disposed of by
Taking into account the contents of your letter.
Lord.
Otherwise, on
Lordship,
1.0A,
before that, my lord, similar line, my lord. Lordship, kindly have a look at page 131, my lord. There are 14, my lord.
141.
131 page, my lord.
Yes.
Lordship, may I read, man. Conjoint reading of the provision along with the above instruction dated so issued by Central District Tax so comes to show that concerned authorities required to issue show cause within 6 months of the seizure. Failing which the goods are to be returned
Okay,
to
we'll consider for some time to put, but for
before that, Lordship.
even in the light of Ambala case also, my lord, I am entitled.
The contention of the petition that the rejection of their for provision to break is not backed by the rather the provision custom act gives the right to the incumbent to have provisional release of goods and they cannot resolve some response. As the can
And the standing council for
central
custom.
custom, however, that are proceeding for the and come back for pass fine road. Consider back this is on 4th of December. On which final order pass.
Much of
All
it.
all development. I mean, maybe not maybe please.
My lord, even if they, my lord, find there is no cavity or nothing, my lord, they are liable for compensation, my lord. It will subject to another writ petition, my lord.
May it please your lord. My lord, this case has a small background, my lord.
I will take for point.
Yes, Lord. That was the observation.
Now, what had happened, my lord, as far as the present building is concerned, present subject matter is concerned, my lord, if your lordship will kindly come to page 114.
114.
Yes, of the writ petition.
Yes.
Now, this is a building permission given by the, my lord.
To you.
Yeah, no. Yes, to the petitioner. Yes. Issue of NOC certificate under section 25 of the
This is
GMBA.
10th November.
Yes, for construction of, my lord, of an RCC building.
They don't.
With reference to your application for permission to erect a building boundary wall at village so-and-so, Moza so-and-so, on proposed 8.50 meter wide road for residential apartment purpose, in accordance with the plan submitted, with the each floor setbacks are shown as below. Now, kindly see, my lord, this permission was given way back in 2009. Now, this proposed road width, my lord, this 8.50 meter, this aspect I'll come little later. First, let me, show, my lord, that this was the permission.
Where do you get it?
Third line, proposed 8.5 meter wide road. The authority themselves has explained what is the meaning of this 8.5 meter wide. I'll come to that. Now, kindly see, my lord, it's only an 8-story building. Now, there was a slight, my lord, modification, and those lordships will find it page 115 and 116. Rather 117 also.
Page 115.
Now, page 115.
What are these?
These are also, my lord, NOCs with some modification. Then my lord will kindly come to page 116. This is very important. Now, what had happened, my lord, between 2009 and 17, there was a proceeding pending in this court, filed by Torun Nagar Unnayan Committee, my lord. They were objecting to the, my lord, this project itself. So that is why, my lord, there was no activities until, my lord, 2017. By that time, my lord, the petitioner financially, his project became unviable. Therefore, some subsequent developments took. If your lordship should kindly come to page 116. With reference to your application for permission to erect at so-and-so, on 4.9 meter and 8.0 meter wide road for residential complex purpose in accordance with the plan submitted with it, with area of each floor and setback are shown below. Now, my lord, it was revised to, my lord, 9th floor. Now, despite this permission, my lord, at page 116 and 117, the petitioner could not, my lord, undertake the project because of economic reasons, my lord. Therefore, my lord, the petitioner entered into an understanding with respondent number 5, my lord, for taking over the project under certain terms and conditions. Just for narration of facts, I have highlighted that aspect. Now, my lord will kindly come to page number 126. Now, what had happened, my lord, in terms of a direction issued by this honorable court in the earlier litigation, this report was submitted by GMDML. And this is very important, and in fact, our case hinges on this. Now, yes. Now, my lord will kindly come to page 126, my lord. 126.
What's the date of?
This is dated, my lord, 1 second.
28 Feb.
28 Feb. Ah, 28/12/13. Now, if your lordships will kindly come on top, brief report on the points raised during hearing held on 23/12/13 in connection with WPC number 7057 of 2013, dated so-and-so, Magmuller versus Fenn. Now, my lord will kindly come to paragraph 2A. Existing road width as on 24/12/13, along with Torunnagar bylane number 2, from Torunnagar Maid Road to the proposed site of Meghamallar Estate, is found to be as follows. Now, in different chains, my lord, there are different widths. And if your lordship will kindly skip over to the next page. Average road width of this Torunnagar bylane number 2 was found to be, my lord, 7.5 meters at page 127. Average road width is computed as 7.04 minus 6 is equal to so-and-so plus so-and-so is equal to 7.50 meters. This is one road. There is another road. This is, my lord, Anil Nagar road. Sorry, this is a existing road width as on 24/12/13 along road link side, and Rajgarh main road is found to be as follows. The average road width is, my lord, 4.68 Anil Nagar road. Now, I refer to that 8.50. Now, this is the explanation of GMD. However, as per the file record, the average road width of Torunnagar bylane number 2 was taken as 8 meter average during the year 2008, based on the average road width of 8.0 meter. Proposal was approved considering the fact that there are 2 other connecting roads to the site. The FAR allowed was 175 against permissible 200 due to variation of road width along with Torunnagar bylane number 2 in the CTC meeting held on 23/12/08 and 3/1/2009, which recommended the proposal for approval with condition stormwater drain to be allowed and developed to the plot from surrounding area of Anil Nagar and Nobin Nagar to minimize the waterlogging problem. The existing road width now available along the Torun Nagar bylaw number 2 is less than that was existing during 2008 when the plots abutting the road were not developed or boundary walls were not erected, and there is apprehension of encroachment of the road since the year 2008 by of development in the abutting plot. As regards to mentioning of the proposed road width of 8.50, this is where, my lord, as mentioned in the NOC, it is stated that FAR is allowed based on existing road width, and proposed road width is considered for determining the front setback so that provision in road widening in future may be facilitated. Now, my lord will kindly see, in 2008, the road width was, my lord, 7 point something. Now, in 2021, when the permission was given, it will be reduced. It can't be enhanced. The reason is, my lord, earlier maybe, my lord, boundary walls were not there. There will be some encroachment. As a result, my lord, it gets reduced. Now, my lord, the catch in the whole case is, lordships will get in that page number, yes, 97. Now, why I have referred to this report, my lord, to show when a query was posed by this honorable court, how come you are permitting a high-rise building of 9 stories in a congested area like Torun Nagar bylaw number 2? The authority justified their action saying there are 2 roads, one from Rajgarh side, it is only 4.5 meter, and my lord, Torun Nagar bylaw number 2, the road width is only less than 8. So based on that road length, my lord, road width, they get an FIR of, my lord, about 175. Now, my lord, an FIR of 275 has been, 225 has been given. Now, please come to page 97, my lord. Map of the existing road leading to the site along with the width of each road. Kindly see, my lord, this Anil Nagar road, it is only 4.5 meters. Just I may indicate, my lord, when we cross the, my lord, the Rajgarh bridge, then we take a immediate right turn towards, my lord, Anil Nagar. Then, my lord, straight we see a small road of 4.5 meters. This is the road. Now, what had happened, my lord, on the side, the front portion, they have taken back their boundary wall. Would the road become wider? Now, this is the catch, my lord. Now, what they have done, just in front of the side, the boundary wall has been taken back. Now, my lord, it is 12.5 meters. So, this is only in front of the plot, not the road. Road is still 4.5 meters. And Torun Nagar bylaw is 7.5 meters. So, there are 2 roads leading to the site. One is Anil Nagar road. Other is, my lord, Torun Nagar bylaw number 2. Torun Nagar bylaw number 2 is 7.5 and, my lord, Anil Nagar road is 4.5. Now, by taking back their boundary wall, how can they claim the road width has increased? This is for your convenience, you have done it. Yes. Now, my lord, will kindly come to the impugned permission, which your lordships will get at page number 88, my lord.
Okay.
88. Kindly mark the date, my lord, 10/9/2020. And also mark one date, my lord. Your application dated 1/9/2020. I wish, my lord, people of Guwahati gets permission with such expedition, my lord. Lordship will kindly take note of few dates. 1/9/2020 revised plan submitted. 3/9/2020 a special committee constituted for permission.
Where are you?
No, I'm just giving the dates, my
What
lord.
are the dates?
Yes. 1/9/90 revised permission applied.
1920
my lord. I'm sorry.
revised permission.
Yes. Which is the outcome is at page 88.
Right.
Yes.
Application for revised permission.
Yes. By this time by respondent number 5. 3/9/2020, my lord, a special committee is constituted. 5/9/2020, the committee makes an inspection.
Yes.
6th is a Sunday. 7th, Madhavdev Tithi. 9th, Janmashtami.
8th.
Yes.
8th.
8th, my lord, it was open. And 10 permission is given. This averment we have made given in our affidavit in reply at page 582. A 21-storied building permission is given in, my lord, virtually 2 days. People make beeline, my lord, for months. People don't get permission. Now, my lord will kindly come to page number 182.
None. It is a part 4. I can't read.
Now, my lord will kindly come to page 188. 188. This part of the, yes, part of the affidavit in opposition filed by GMDA. Anyway. Minutes of the meeting held on 5/9/2020 in the office chamber of the Secretary GMDA, as a lordship got it, regarding evaluation of proposal of Protect Housing at village Japurigo. A proposal of group housing residential apartment building comprising 5 blocks, Block A, G+11, Block B, G+10, Block C, G+21, Block D, G+21, Block E, G+13, submitted by Messrs. Protect Housing was received online. However, due to large size of the proposal could not be processed online, as AutoDCR software failed to run the program and halted time and again after certain limit of progress. This has been duly examined and certified by Sunita Sharma of Messrs Software and Satyajit Bora, IT consultant, etc. Thereafter, the applicant submitted hard copies of the personal proposal for further scrutiny and processing of the planning permit. In the meantime, Chairman GMDA, my lord, the chairman is the, my lord, father of the 2 directors of the applicant company. In the meantime, Chairman White order dated 3/9/20 constituted a 3-member committee with the following members for scrutiny and recommending of planning permit proposal over 10 bighas of plot of land. How far it was correct, my lord? I have my doubt. Doctrine of necessity cannot come. The committee examined the aforesaid proposal and visited the site on 5/9 to study the ground situation. Measurement of the road was taken by Subhas Mondal and Torundas Mondal of GMD at various sections of the road. The width of the road, Torunnagar byline number 2, at the last junction point or to the point in front of the plot and at the point where the road width is minimum are as follows. Entry point near Namghar 8.05. This is absolutely wrong. In front of the plot 12.5. What a unique way, my lord. Minimum width of the road 4.5. As per the Guwahati Building Construction Regulation 2014, the average road width is defined as follows. The width of a street road means the clear average width of the existing carriageway and footpath and drains only on which the building or plot abuts. The minimum width of the existing and the proposal width prescribed by the authority will be taken for calculating the maximum permissible height of the building. The average width shall be computed by taking the width of the road at the junction point leading to the plot, in front of the plot, and the point where the road width is minimum. In case where the road width of the street road is not regular or uniform all along the road of the road, provided minimum road width is available at entry point in front of the plot. On the basis of the above provision, as the road width is not regular, the average width of the Torunnagar byline number 2 is found as follows. 8.05 plus 12.5, my lord. If 12.5 is, my lord, deleted, my lord, it can't be 8.35. It has to be below it. It's 7.5. My lord, Rupnagar Road in front of my house is 9 meters. If I take back my boundary wall, the road width of Rupnagar Road will not become 11 meters. So, my lord, this is an, improper exercise of, my lord, lawful authority. As per bylaw 24A1, the wider road is considered for determining building height and other regulation provision is followed. And my lord, these are the justification. Main point is, my lord, the the portion in front of the site, merely because the wall was taken a bit, that cannot increase the road width. Now, my lord, all these calculations are given. Now, building height, and therefore, the maximum eligible height of the front blockage shall be 1.5 into so is equal to so. Similarly, for other block, height of the building are examined and found to be within permissible limit. Coverage of the footprint of building.
Now, what is the permissible average which were?
No, my lord, if it is actually the road is 8.35, then they're right. Then the authority.
What is the minimal word?
There is nothing minimal or maximum, my lord. Question is depending upon
to have a height of 21 floors. What is the minimum width?
Above it.
Above it. That is why you say that 12.5 has been included to make the average, to inflate the average.
Yes. Now,
but another aspect we right.
Yes,
how much was the length of the road in front of the compound?
In front of the compound, it would hardly how much, my lord? Maybe 100 feet or 200 feet maximum.
And the entire thing?
And that road. That road is, my lord, it will be about, I think, my lord, in the earlier case, the chainage are there. Please come to page number 126.
No, I'm just
yes.
thinking aloud. While expecting an average, it's not that to take average of the width.
Particular portion.
They have to take the portion.
Exactly.
Yes, that's the ratio. If it's 1 point, it is 100 feet, it is only for that point.
Yes.
You cannot make that you take the average.
Supposing the road is for 600 meter, in 100 meter, if it is 12.5, but the whole road cannot be taken to be of that. Average, my lord, if your lordship will kindly come to page 26.
26?
126 in the writ petition. Now, Even that 8.05 is also wrong, my lord. Even that 8.05 is also wrong. 126 of the writ petition. When this report was filed before this honorable court by the same GMDA, nothing has changed. Rather, situation may have turned bad. Kindly see, my lord, as far as Torun Nagar byline is concerned, chain is 0 to 29, it is 7.4 meter. Chain is 30 to 59, it is 7.6. So this is how, my lord, in different chainage it is there. If your lordship will kindly skip over to the next page. So only on chainage 421 to 450, it was 8.50. Therefore, my lord, the average was computed to be 7.50. It was less than 8. Now it cannot become 8.05. Over a period of time, now my lord will kindly come to 127 for different chainage of the Anil Nagar road, which is 4.5 meter wide, now which is sought to be made 12.5 meter. Kindly see, chainage 0 to 29, it is 5.10. Similarly, it has got 480 meter, my lord. So, in front of the plot, it could be maximum 100 or 200 feet.
Average was 4.6.
4.6.
Where do you get?
Because, my lord, now they are taking in front of the house, it is 12.5.
But it is Anil Nagar.
That is Anil Nagar.
The other one,
Torun Nagar now 7.5 has been made 8.05. And my lord, 4.5 has been made 12.05.
where do you get?
Yes, in the, my lord, at page 189. Sorry, 188, my lord. 188.
Yes.
Kindly see, my lord, somewhere in the middle, entry point 8.05, in front of the plot 12.05, minimum width 4.05, 4.50.
Third point.
Huh,
Where is the average?
No, my lord, average is 8.05.
But
And
we are,
average is 8.35.
we are not taking average. We are just taking the
Tarun Nagar.
road width at that point. It is not the average.
Not average is two paragraphs thereafter.
Huh.
Average road width
Huh.
is
This is average.
No, 8.05
Uh,
plus 12.50 plus 4.50.
8.35.
Thus it is 8.3.
This is Tarun Nagar. And what about
No, both, my lord, Torun Nagar and Anil Nagar. Because this 12.50 is in respect of Anil Nagar road, which is otherwise a 4.5 meter wide road. My lord, if a commission is given, everything will be clear, my lord.
Where is that map?
Yes. Map is at page 97. Anil Nagar, my lord, it's a road where even one car cannot pass, my lord. Even today, people have to take that on the Torun Nagar byline number 2 only. Kindly see, my lord, 4.5 meter wide. Now that portion, shaded portion, my lord, that is the side. In front of the side, now this is 12.5. So road doesn't become 12.5. Am I clear, my lord? My lord, we have explained this position in our affidavit in reply. Yes, page number, my lord, in our reply, 581. Hmm?
Five fifty-one.
Yes, it starts, my lord. My lord will kindly come to page 585. My lord, we are questioning the constitution of the
585.
585. We are questioning the constitution of the committee because respondent number 6, my lord, he should have recused in this case.
Where?
Yes, 585, my lord.
Assuming.
Yes.
Assuming.
Assuming without admitting that the 3-member committee is validly constituted, perusal of the minutes dated 5/9/20 clearly reveal the erroneous computation of average road width for the purpose of determining permissible affair of the said committee. The 3-member committee took recourse to para so-and-so to calculate the average road width. 3-member committee had come to a finding that plot in question has tri-connectivity and the same is not denied by the petitioner company. And average road width of Teuzi Ali and Anil Nagar by-lane was shown as 5 meter and 4.67 meter respectively. However, the 3-member committee is silent about methodology as to how committee undertook the measuring of the aforesaid two roads. With regard to Torun Nagar by-lane number 2, the 3-member committee came to the following finding. Entry point 8.05, about in front of the plot 12.05, minimum width so and so. As per the report dated 28/12/13, the average road width of Torun Nagar was 7.5 meter and report indicates the methodology as to how the average width was arrived at. That's at page 97. At that relevant point of time, building bylaw 2006 was prevalent and section 20, which is perimetria to so and so, which dealt with the calculation of average road width for the purpose of calculating FR. Further, as per the aforementioned report dated 28/12/13, the average road width of Anil Nagar by-lane number 1 was 4.68 meter. Now, 3-member committee, while calculating the average width, ought to have calculated in the following manner. Entry point so and so, in front so and so. In the report dated 23/12/13, the widest point was the portion was 5.10, as well as the wall of the plot has been moved back and widest portion comes to 12.50. And as such, the new calculation becomes 12.50 plus 3.95 plus 5 is equal to 21.45. And after dividing it by 3, it comes to 7.15. The width of the bridge is 4.5 meter. As such, the average road width of Torun Nagar lane number 2 comes to 6.57. However, 3-member committee, instead of considering the actual road width in front of the plot, considered 12.5 meter as because respondent number 5 moved the boundary wall backward. This action of respondent number 5 as well as the action of the respondent authority is wholly illegal against the spirit and mandate of the bylaw. Then C also, my lord. Again, assuming without admitting that 3-member committee has statutory competence, it is submitted that recommendation dated 5/9/20 is untenable on the ground that 3-member committee nowhere mentions about the long history associated with the plot. The said plot of land was in the midst of litigation since long. Further, the project was envisaged in the year 2009, and thereafter a number of report orders were in existence with respect to the project. The 3-member committee did not even make a whisper of the order dated 15/3/2000, report dated 15/3/2000, letter dated 9/1/15, 22/2/15, and order dated 24/2/14, and judgment and order dated 27/8/18 passed in WPC numbers. The letter dated 9/1/15 in para 6 mentions that petitioner company was supposed to spare a private thoroughfare of 24 feet width across the project site from south to north, directly linking Torun Nagar by-lane number 2 in a disaster situation for use by general public and disaster management team. The 3-member committee nowhere talks about why recommendations while letter dated 9/1/15 and other subsequent letters were given a go by. To the best of the knowledge of the petitioner company, no such road exists in the present project. Thus, it is seen that above three-member committee is illegal and his report dated smacks of foul play to favor respondent number 5, and in turn the Honorable Minister to get a windfall profit of 150 crore. My Lord, in the earlier permission, there was a necessity of a third road also linking two road, my 24-meter-feet wide road. Even those are now, they have not referred to anything. As an obedient, my Lord, government servant, because respondent number 6 has constituted a committee, and my Lord, they without applying their mind, by consigning, by mortgaging their conscience, my Lord, they came up with that report. My Lord, a building permission of 21 story is given in 2 days. Nothing more is required, my Lord. Can a citizen expect that same treatment? It's unheard of, my Lord. We all know how long it takes. Now, therefore, the question is, my Lord, apart from anything else, Guwahati being a, my Lord, in the seismic zone, that aspect also requires consideration. Earlier, the foundation was done by the petitioner. It was meant for 9 story. Foundation was for 9 story. Well, My lord will kindly come to page
You
number.
said the quotation was done by you for 9.
Yes, initially it was 9 crore. No? Yes.
Two eight. Two. Yeah. Two 275. What price about
My lord will kindly come to page number 98 of the writ petition. This is the bylaw of 2020, my lord, the benefit of which was given to the respondent number 5.
Yes.
If your lordship would kindly come to page 101. There is a box, my lord. Third from the bottom. Existing road width above 6.6 meter up to 8 meter, as the lordship got it, my lord. Then maximum FIR is 175. Then if it is above 8 up to 15, then depending upon the plot size, it could be 225 or it could be 275. Now this benefit has been given. I think, my lord, apart from anything else, I think a criminal case should be initiated against this 3-member committee, my lord. I think a commission should be appointed, my lord, and really it should be passed out. If I am wrong, my lord, lordship should impose exemplary cost on us. If they are wrong, my lord, criminal proceedings should be initiated. If we are wrong, I am repeating, my lord, we should be penalized. And if they are wrong, my lord, criminal. End of the day, my lord, they enjoy a public trust. They are nothing but repository of public trust. This is how, my lord, they are discharging their public trust? A 4.5 meter road, a 7.5 meter road has been made, my lord, 8.5 meter. That too, by, my lord, arranging a boundary wall only. My lord will please come to para 22 at page 20. Page 20, para 22 of the writ petition. That the petitioner respectfully begs to state that as far as the legal wrong which has been caused to the petitioner for entering into MOU dated 9/11/19 and deed of agreement dated 6/6/20, the petitioner will pursue its legal remedy in appropriate forum. However, the present writ petition has been instituted to redress the grievance arising out of the planning permit and NOC issued by GMDA and GMC respectively. What is evident from the facts narrated in the preceding paragraph is that respondent number 5, in collusion with GMDA authorities, managed to get an FIR of 2.75 when in law the entitlement is only 1.75 or at best 2. This has become possible because of so and so and so and so, who are the partners of respondent number 5 partnership firm, are sons of so and so, etc., etc. It is the specific contention of the petitioner that it is a unique case where the minister has blatantly misused his position to do undue favor to respondent number 5 for wrongful gain, where both his so and so have decisive stakes along with their partner Sri so and so. It is worth mentioning that because of the enhanced affair, respondent number 5 stands to gain approximately 2.5 lakh square feet of saleable area. When this enhanced affair of 0.75 is computed, 2.75 is computed in terms of money, it comes to approximately 150 crores. Therefore, what is evident is that in order to make windfall profit of 150 crores, where everyone gets a piece of pie, the above illegality has been committed by respondent authority. Nothing more is required to show the abuse of the power by the executive at the behest of so and so. Though has not been arrayed as a party respondent, anyway, my lord, subsequently, pursuant to Lordship's order, he has been arrayed as a party respondent. Now, my lord, regarding locus standi, also the other side might pose a plea, my lord. Therefore, we have answered that also in para 24 at page 22. The petitioner respectfully begs to state, page 22, my lord, para 24. I think, my lord.
How long will you take? Then we can take a break. Are you
Another
coming to an end?
10-15 minutes?
Then we-
Okay. Yes.
Page 20.
Yes. Page 22, my lord, para 24. That the petitioner respectfully begs to state that what is sought to be projected in the present case is an instance of an blatant abuse of authority by the minister concerned to favor an entity where both his sons have above named stake. The present case is not a PIL but a petition filed by the petitioner for enforcement of his fundamental legal right. What distinguishes a PIL from an adversarial writ petition is that role of locus standi is relaxed in case of a PIL vis-a-vis a writ petition. But both a PIL and an adversarial writ petition belong to public law realm. Apart from personal legal injury which has been caused to the petitioner by execution of the MOU dated so and so with FIR of so and so, the petitioner is also highlighting the violation of the aforementioned building bylaw framed by the competent authority under the relevant statute. The moment and litigation involves violation of statute by public functionaries to bestow favor to anyone which is otherwise illegitimate, public law remedy can always be invoked. Having regard to the aforesaid legal proposition, the present writ petitioner has instituted seeking to invoke the jurisdiction of this honorable court. Now, my lord, therefore, in nutshell, as far as my personal injury in the form of loss of share or income is concerned, my lord, for that, my lord, I'll pursue my remedy in an appropriate. In fact, my lord, I have already started an arbitration. In fact, this honorable court has already appointed an arbitrator. So, that part, my lord, will pursue in an appropriate forum. Now, because, my lord, my name is also involved. Tomorrow, if the building falls, people will, they speak about me also, because my logo is still being used. Meghamala's logo is still being used, my lord. Many people may have come forward to buy the flats because I was also involved, but I am also involved in some form or the other. Now, end of the day, my lord, is it not a case where a political executive, my lord, has misused his position, that to favor his own, my lord, sibling? And my lord, it's a case where the illegality is writ large. Therefore, I'll humbly pray, my lord, if what we are stating is wrong, please penalize us by imposing exemplary cost. Therefore, what I'll humbly pray, my lord, let a commission be appointed. Let a commission be appointed. Let commission make a measurement of the two roads. And, my lord, they should also take note of the earlier conditions in the NOCs, my lord, where there was a requirement of making, thorough road. Then, my lord, there was a requirement of making one 24-meter wide road to that Heusi Alley towards Jew Road. Those are not there. All of a sudden, overnight, a 4.5 meter road width has become 12.5 feet. It's unheard of. And my lord, in the earlier report, the DMD authority clearly indicated that the measurement is of 2008, maybe over a period of time, because many boundary wall has been constructed by different my lord plot holders. There is every possibility that road width will come down. It cannot increase. So my lord, this 7.50 becoming 8.05, it's a my lord, the issue which needs to be examined. And if what I am saying is wrong, my lord, everybody should be taken to task. So my lord, that is my humble submission, my lord. This NOC, this cannot withstand legal scrutiny, my lord. This is required to be interfered with. Let an independent commission be appointed. Let commission find out what is the width of these two roads, my lord. Then everything will be out of the, my lord, the back. Let town and not government agencies, my lord. Some private agencies will have to be engaged. Because government agencies, again, they will influence my. Because I was thinking of town and county planning, again, it is under his ministry. So it will be futile. Huh? Oh. And my lord, under civil procedure code also, there is a provision for appointment of. So my lord, this is my submission, opening submission, subject to what my learned friend, my lord, argues. My
Take a
lord.
break.
Lord, if I may I just,
We'll come in 5 minutes.
no, I am taking a different. Whatever my learned friend has submitted, in our affidavit, we have basically stated everything. I just want to go through the record because I have to make a final submission.
Right.
Regard. So if the matter can be taken up day after tomorrow. In the meantime, I'll verify all the records and make my final submission.
No problem.
Day after tomorrow.
But we have heard this.
Yes,
It will
Lord. If
come
his
as
side
part
is
of-
over, so our side, and another case, Lord, for the minister Rajiv Borpujari appeared, so he has engaged Rajiv Borpujari on bereavement. So he has engaged G. Gogoi, and some new council will come there. That
We'll come.
Okay, no problem.
and it will come day after tomorrow. We'll complete it, Lord. With the record, I will make my.
Okay.
My
After
lord,
tomorrow, you have
Thursday, only thing is, my lord, I am told by my junior. Anyway, my lord, let them, in case of any difficulty, Rocky will accommodate.
okay.
Otherwise,
And,
let it be on Thursday.
otherwise, you have made your submission
Yes,
substantial.
insufficient.
Only a reply which we may
Yes,
call
yes.
for. We'll have it day after tomorrow.
I'll try my best. In case of any difficulty, Rocky will accommodate for a day or two.
Are you discussing on fact?
Totally different picture is projected. My fact will be totally otherwise.
What about the map?
The map, at that point of time, there was no road in front of it. The bridge was constructed very recently. So the whole scenario has changed. The whole ecosystem.
My lord, bridge was built by me. My learned friend is
but,
not even aware of.
So all the
They
all
wrote
the
that.
submissions he is making dates back to 2013 and 2019 when there was no bridge.
So, my lord, bridge I constructed.
And
My learned friend is not even aware of that.
2008 permission itself shows the proposed road width is 8.5. His own documents. I'll make all my submission on his documents.
But what about the period of only a month, only 2-3 days?
Only thing is, Lordship, he wants more share. That is the only thing. I have all the documents. If he gave share from him, it's an internal dispute, and I am just in the.
Well, nobody has
We- no,
fallen
we
from
have
heaven.
Also,
So,
we have also thought about that aspect. But
That is the main aspect.
leaving
Lord.
aside that aspect, the element of public,
Public interest there is
public
absolutely no issues.
21 stories in 2 days. How
No, no, I think 21. He will make my submission
yes, yes.
because they have taken all necessary requirements, the reinforcement, and he has constructed the foundation.
And when foundation is for 9
No,
stories,
no, that is an incorrect submission. Lord. Nobody will take the this what you call that noose on his neck. No, that is a popular submission made in the public media also, but which is not correct.
9 stories. Foundation.
Nobody will do that, Lordship. A 9 stories
We are
foundation will.
mainly you're concerned about the public, nothing else.
Absolutely, Lordship.
But he cares
And
whether,
in fact, on the very first day, I said,
Athak's plan
let
can
there be a
announced
commission.
too much. We should ensure that there is not be
Yes,
the
Lordship.
problem
Or
for the
that the
public.
IIT can be also called for. I'm adding one more study. Nobody will take that risk, Lordship.
AG appears to be very sanguine. Even IIT may be called for.
Yes, Lordship.
Actually,
My lord, in this country, in
we
this
hope
country,
that-
my lord,
Only problem is that
My
the
lord,
share.
in
the
this
share
country,
is
my
the
lord,
problem.
nowadays, everything is being managed.
Yes.
Every agency.
If that he does not have, yeah, if Lordship give the judgments tomorrow, he may say this
No,
also.
no, that is the only
No,
institution to whom
that
we should look
that
forward.
submission may also.
No, no, this will not come. Don't worry. That is the
Yeah,
only
nobody is going
institution
to
we are
manage
expecting
anybody.
that they will deliver.
Nobody has any
See,
interest. Lord.
Mr. Saikya, we cannot stop people from talking.
Yes.
But we have to do our respective jobs
Exactly,
Yes.
Lordship.
to the best of our conscience and
Lord,
aspire.
Yes, yes.
And
Absolutely, Lordship.
on a second thought, IIT,
we
we
must
also
have-
have grave doubts. Mr. Chaudhary will be knowing why.
Now, the
My lord,
problem is,
I
Lordship,
was just thinking of one aspect, my lord. Why respondent number 5 even touch the file when his two sons are involved? Is it not forget about illegality, propriety demands, my lord. Then, my lord,
Heard. This third case, total consumption account at some time. Three, this case done it 80. However, sufficient that he may spend some time to go by original record and raise for topic for further consideration on Thursday on date. The 80% constitution for that's one number 5. Anyone else? Mr. Gogoi for
for the
where
minister.
the where's P. Gogoi when it comes to the as agreed to by the parties, this for further consideration on 23rd.
Highly obliged.